it's a useless if you have total liberty, and if you do not have total liberty, if you have mentorship by a professor, then he or she will tell you, well, that's the topic with too many writings about it. We don't need yet another one on the same topic with the same sort of results. So that's the objective thing. Some topics can be, in a way, can become less important in a certain period of time. So they can be, in a way, historically less relevant or scientifically less relevant. So, or in the same area, there would be issues that are far more, in a way, relevant and hot for the current moment. So these are the objective elements which you have to take into account. And within this subjective objective set of elements, you have to kind of pick the relevant topic. But again, the topic that will first and foremost match the writing that you are undertaking. So, for the essays, which are 10, 12 pages long, obviously you have to quite narrow the research issue and to be as precise as possible in elaborating this problem. Whereas for master thesis, you know that you have at your disposal about 40 to 50 pages, which is kind of, master thesis is very peculiar, very unique type of writing. So that's very funny, like people who have the least experience in writing are expected to produce the most peculiar type of writing, because usually no one will allow you, or in majority of journals, you cannot write an article which is 40 pages long. So that's, for most journals, this is not acceptable thing. And it's too short for a book. So it's between two most traditional types of writings about law. One is article, the other is book, monograph. But for 40, 50 pages long thesis, obviously that can be a bit broader topic, but less broad, more specific than merely accession of Serbia to the European Union. That's already a very, very broad topic. So this is the most I can tell you for how to pick the topic. I cannot kind of provide any further miracle information. But we kind of try to circle the ground at which you need to define the topic. And obviously, in picking up the topic, you will have professors as your kind of advisors on this issue. And not only in terms of master thesis, but also in terms of some essay papers. Second question: how to find relevant materials? First, what are relevant materials? What are relevant materials for our writings about a certain legal problem? what are the standard relevant materials for writing about legal issues?
Other relevant books and articles on that topic.
Okay, so in a way, the literature that is already covering the topic, but what else? I mean, if you want, for instance, to write about accession or any aspect of accession, Serbia to the European Union, so what would be your primary material?
So, of course, books, as he said, but it would need to be something that legitimate knowledge, for example, information from the website and from Ministry of European Integration is relevant, but if it's, for example, from Wikipedia, it's not that.
Okay,
Yes.
okay, in that sense, yeah. But
So,
what would you pick up as for you as something without which you cannot really write about this topic?
so or some I'm working in Parliament, so some institutional knowledge that we already have. Institutional knowledge, some documents that we have that they have data information. Also, some European documents.
When you're saying documents, what are you referring to?
And based on treatments, for example, treatments.
Well, obviously some typical
For
legal
example,
material.
annual report of the European Commission is the most important document. But there are also non-papers, for example.
Annual report is about what? About the accession process. Yes, and progression is measured according to which document?
Of course, it's measured from mostly from a technical perspective, commission employees, but our institutions.
But what is the most important? What is the basis for the very process of Serbian integration to the European Union?
The basis.
Yes.
Yes. Case documents of, for example, NPA, our Serbian documents that are.
So the accession agreement, isn't it?
Yes.
Well, that's the thing. The lawyers first look up for some legal norms. So either they are in treaties, either they are in statutes, either they are in judicial decisions, either they are in decrees, constitutions. That's the usual material for some daily work. So first, we need to find the relevant material in terms of some valid law, if we are into valid law. If we are not into history of law, then we will be referring to some historical sources. So that's the first thing. So if you need to find anything in European law, where would you go?
Treaties.
Where to find it? How to?
Okay, there's a website. I'm sure that's not the question actually. But
Well, yes, it is the question. Actually, it is the question.
there is a website where every European law is everybody's.
Yeah, that's for instance important thing. So you will have you will have the special class with our librarian who will be speaking to you about the available sources. So literally the web pages where you can find certain materials, general materials, and some specific materials. So this step of finding relevant materials is today immensely simplified, immensely democratized. A lot of knowledge is basically out there for free. Even that knowledge which you have to pay, sometimes there are ways and means for getting them for free. Of course, not legally, but the thing is that almost all relevant materials, at least for you working, for instance, on master thesis, almost all materials can be found, can be researched online. It's available on certain databases, which is obviously the biggest progress in terms of scientific research. And if you compare it to what was happening only 30 years ago, but basically you would have to go to library to find a book, to copy the book, to take it to your copies, or there are no books here. You go somewhere, you copy like 2,000 pages, then you have one suitcase of only papers, returning back with that. Okay, now I'm telling you my kind of early days of my career, but basically that was really the case 30 years ago, and now basically you can access everything. You can find really almost everything online. When you are trying to come to some relevant material from judicial practice, this sometimes may be the problem. For instance, let's say on the master program in law and gender, you are interested, for instance, in family violence, and you want to find all the relevant judicial decisions. This might be problematic because judicial practice of different Serbian courts, this is not always available, accessible, and so on and so forth. So sometimes there are problems. But when it comes, for instance, to European Court of Justice and their jurisprudence, everything is out there. It's available completely. So this is really a huge step forward in comparison to what was previously the case. Okay, you have the topic. You were told where to find things that are important. Next question: how do I make a plan of what to do, how to write things? What would that initial plan contain? No, go ahead. Just introduce.
To have something like hypothesis, what you will take at the end of your paper, like what from to what I need to go.
Mm-hmm. Okay, that's a good point. So picking up the topic is one thing, but you have to translate the topic that you've chosen into some sort of a thesis. That's why it's called master thesis. You need to have some sort of a claim of the key argument, main point, which you are putting in your thesis. And you want to defend it, and that's why we have master defense or PhD defense, because the candidate needs to defend the main thesis. So it's one thing to pick up the topic, it's another thing to formulate the thesis. That's very important. That's very important, obviously. It's the third thing to formulate it into a title of the paper. Obviously, even when you know the topic, you translate it into thesis, you need not put in the very title the argument that you want to pursue. Sometimes you may find some kind of more interesting, more witty, more funny way of making a title. But it's important for you to know what is the main thesis of your writing. And when you formulate the thesis, what's the next move? So you have, let's say, let's now presuppose that you are writing a master thesis. So you picked up the topic, you formulate the thesis, you know I want to show this, and what's the next part of your plan?
So I think that even, for example, in introduction, if you already have something in mind about conclusion, introduction should be a little broader than conclusion itself. Starting from other position and then
Introduction and conclusions are part of the entire structure, or if you like, the content. So you have the thesis, but then you need a content, right? And when you are thinking about the content, you are thinking basically about how you will structure the whole thing, which means how many chapters do I have? I have 50 pages, let's say. What would you say? How many chapters you can put in 50 pages?
2 or 3.
2 or 3. What the others say?
I think more. That's
More?
I'm trying to see to visualize in my head some books that you gave us. They're more than.
Well, these are books. Again, don't forget, master is short, and 2 or 3 plus introduction and conclusion. Yeah. Well, you see, you already have some kind of inner gut that something shall be taken, and this is not just an inner gut, because you already saw some examples. So before writing a master thesis, it's a good idea to go find some master thesis. And you can ask from your professor, can you recommend me some good thesis in this program? He or she will recommend you some thesis, and just go and see how it was structured, because that's also a smart thing to do. So the very important step of writing any type of writing is to have this sort of plan. So I do pick up the topic, I picked up the thesis, and I do have some sort of a structure. And this structure means I will have, let's say, 3 separate chapters. But not only for the sake of having 3 chapters, but for the sake of having 3 narrow issues that will be elaborated in each paragraph, right? Or in each chapter. So it's always kind of it cannot be mechanical thing. Sometimes you will need 5, maybe 5 shorter chapters, depending on the topic that you are writing. Or you can put everything, squeeze everything into 2 bigger chapters. It really depends on the topic and the thesis, how you, but it's connected. It's important to think of it. Not to say, oh, professor told me it's 50 pages, it should be 3 chapters. No, that's not kind of, we are not speaking about mathematical formula, which will by the end of the day produce a correct result. This is very kind of contingent thing. It depends on what you pick up, what you want, and so on, so forth. It's always good to start with some sort of a plan. And very important thing, this plan very often changes throughout your writing. You start from one thing, but sometimes you end up with completely different thing. Sometimes you end up with completely different thing. That's why it is important to try, when you formulating this plan, the structure, to write an abstract. You saw that articles in the journal normally do have abstracts. So what is the point of abstract? What would you say? What is the point of abstract? We will also ask from you to have an abstract for your essay or for your master thesis. What is the point of abstract? Go ahead, don't be shy, 2 of you. Don't be shy. Did I scare you? No, it's okay. No, I don't want.
Yes, I'm here for you, but I just...
Okay, thank you. No, I was just thinking of you getting inside the discussion, not being very silent. So, what is the point of abstract? What do we want with abstract?
To express, I think it's to express the conclusion of the subject, and after the subject, we can also to express what you want to say and to divide it into some paragraph or the capture. That's what I think.
Well, yes, basically we want to show to the reader, what to expect in the paper, in the thesis, in the essay, in the book, whatever. Okay, we do not write abstract. Usually we do not write abstracts for the book, but for those other writings, we do write abstract. So there are different styles of writing an abstract, but I would really recommend the one which we now heard. Basically, you provide the reader with some sort of a preview, what he or she can expect from your writing. So there you state, in this paper, I want to defend this thesis. In order to do that, I will provide argument 1, this and that. I will provide argument 2, this and that. Then I will see the criticism of argument 1 and 2 in the third part of the book. And I will conclude. So something of that sort. That's how abstracts are written in Anglo-American style. And trust me, this is the best possible way, especially for beginners, to pursue this way. Because when you write an abstract in this way, you also clarify to yourself what you want to do. And you also make a preview to yourself of what steps you will be taking. Okay? And you want people, if you are in business of writing articles, you essentially want people to read your paper. And that's why abstracts are very important. So as you will see, there are a number of scientific research bases which are totally open for you, so you can access them from your home. Academia Edu, Social Science Research Network, ResearchGate. Those are the web platforms at which you will basically need to create an account, which does not, you don't pay anything, you are not obligated to write. You can only download things that some other people put there. And you will find there enormous resources, basically on all those bases, on all those platforms. You have some which are specific, like Social Science Research Network. Obviously, it's social science. It's not for natural sciences. The other two, Academia Edu, ResearchGate, they are for all sciences, but you can easily search by writing some keywords. And what you will find, you will get an abstract of certain paper. So people want readers to go into the article, to download the article, or to read the article. So basically, it very much depends on how skillful and good is your abstract. Because researchers also are in search for clicks, like different clicks. You have Instagram clicks, and here you have downloads, and then you see whether it is downloaded many times and so on and so forth. It's the same sort of, vanity issue, Like he wants to be read by people, he wants to be downloaded by people, and that's why abstract is important. Of course, that will probably not be the case with many of you. I'm just trying to show you why the abstract is of the huge importance as the first step. Citations, quotations, that's also something which basically, usually this is the thing where you have to follow the guidelines. So we have guidelines how to quote things for, we imported the guidelines of our journal, Belgrade Law Journal. So what you need to do is basically to scrupulously follow the guidelines. It's a very tedious thing. It's very boring because every journal has its own guidelines. So there are some general ways of how to cite, quote, but very often you have to follow some peculiar requests by the journal. In terms of more substantive issue, do I need to have many footnotes? How many text? How much of a text should be in a footnote in comparison to the main body of text? There are no correct answers. There are no correct answers. You want to avoid, let's say, two extremes. You don't want, not only don't want, you will not be allowed to write a paper as if everything came out of your head and nobody ever had written anything about that, so you don't have quotations, you don't have resources that you are citing, you don't have essentially long bibliography. That's one extreme. The other extreme is that you don't have anything of your own. You rely completely on other people's references, on their thoughts, on what they said, what they written. So you have to obviously be somewhere in between. Somewhere in between. There are basic rules concerning the prohibition of plagiarism. It's very simple to avoid plagiarism. Whenever you are taking someone else's words, either completely word for word, or you are rephrasing it, you always have to put in a footnote the author, the book, the article, page, and that's it. And you are then you are not in violation of any rule. So that's the kind of the main thing that you have to main thing that you have to apply. And well, and then we come to the problem, to the issue that no longer belongs simply to these skills and techniques. And this is how really do I research my topic and write about it. So we kind of know everything around it, but now we come to the crux of the problem, how to really research my topic. That's the matter of legal methodology. Let us make a 10-minute break. You can take now this. Yeah, it doesn't circulate the material. Thank you.
Ministarstvo kulture je u proteklom periodu intenzivno radilo na prikupljanju kulturnih dobara koje se nalaze van teritorije Republike Srbije i to kroz otkupe putem prodaja na aukcijama.
Reč je o jednom veoma reprezentativnom svećnjaku koji je bio deo dvorskog mobilijara kraljevske porodice Obrenović. Naročito ističem kraljevske porodice zato što, za razliku od mnogih drugih predmeta, ovaj na sebi nosi srpski državni grb. Reč je o veoma luksuznom svećnjaku visine 78 cm težine. 8 kg i 30 grama čistog srebra, što ga čini najvećim predmetom izrađenim od srebra koji danas u našem posjedu da je pripadao dvoru dinastije Obrenović. I ono što posebno krasi ovaj svećnjak jeste skulptura boginje, dakle grčke Nike ili latinski Viktorije, tako da povratak ovog predmeta u našu zemlju ima za nas poseban značaj i mogu slobodno da kažem i bit ću ličan, nešto čime se lično posebno donosi.
Ministarstvo kulture je u proteklom
So the traditions are really good. Oh yeah, oh yeah, and the voice that exists. That's crazy.
Hi.
This is my first time to come here,
Okay.
and I have applied for this major. I mean, this professional major, and into the main office and the main school. But I didn't got the confirmation letter, because I'm from China,
Okay.
and during my
So you don't have still your
Yes.
accounts. You cannot get into
yes.
Moodle.
Yes, and in the previous, I have submitted all my materials to the main school, and they told me that they need to the committee will have a talk to see if I'm qualified to go into their lesson or not. And after they're talking last week, and they told me that they should be the faculty of law to talk it, and then will to consider if I'm qualified or not. And so, but before they told me that maybe I'm not negative to come here, but. When they told me that they also need the faculty of law to talk it again, I think maybe it's possible for me for the enrollment, because before I go to the main office, I have to go to the office of the faculty of law, and I replied the teacher from the faculty of law, and she told me that to think I'm qualified for the enrollment. That's why I didn't go to there have a lesson before, and that's why
But did you get my emails with the presentations?
Yes.
Okay.
I have got all the emails, but the teachers from the Faculty of Law told me that I'm a conditional student. If the main school they refused me for the enrollment, and the Faculty of Law will also refused.
Yeah, okay, but for the moment, I mean, you can come. That's okay.
Yeah,
If you
yeah.
ask me whether I understand your situation,
Yeah.
I know that there is this process, but don't worry. You just participate. I'm pretty much sure that everything will be okay.
You
So,
think I'm okay?
yes.
Thank you very much.
I mean, I cannot tell you for sure, but
I'm willing to join this class, and
Yeah.
I also want to apply for the master's European integration. So I have
Don't worry.
go to main office many times, but now
I will see with them why we are still waiting for that, but I'm pretty much sure that everything will be
Okay. Thank you very much. But I didn't have the electronic account.
I know. That's but I'm sure that they will assign you one when you get. That's something I cannot fix. For the moment, I can only send you the materials, and that's
Thank you.
yeah. So
As for the homework, do you think how should I do?
well, there is still quite some time for doing those. These are not homework; these are assignments, and they have like the period until when they are to be submitted. So there is enough time for that. So don't worry. I mean, you can ask your colleagues just to send you the very
You mean
questions.
that I can let my friends to deliver my
No. They just ask them just to send you the questions of the assignment. You can think of the answers to the assignments. You can write them now, for instance, in your Word document. But when you get the possibility to come to Moodle, then you have just to copy the answer that you already put. Just put it in the regular.
But I didn't deliver my homework on time. Do you think that is okay?
No, there is no. There was first two assignments that are put. They do have the deadline for sending answers is somewhere end of December. So you are fine. You have time.
Okay.
So don't worry.
Thank you very much.
Can you call them just to get inside?
Okay. So we will have in the class. Okay.
Did you receive something? Okay. So we are at the point of describing some of the main methods for researching law. As I said, I will not go really into detail. but we'll need to explain the main differences between the main methods that we use when writing about law. I picked up these three methods: description, conceptual analysis, evaluation, because those are the most common methods that are used in the different writings about law. So description. Obviously, describing is about telling something about certain phenomenon in a way that you essentially picking out some important elements of what you are describing. If I have a task to describe this table, I can say something about the table, that it is made out of wood, that it's brown, and so on and so forth. But wood is a part. The table is a part of physical reality. Just as are some of the possible topics of other scientific works, mostly by natural sciences. Natural sciences are interested in nature, so in what is, for most part, the physical reality that we are situated within. But when it comes to writing about law, we are very often focused on, let's say, some statutes. We want to know, for instance, what are the norms, relevant norms of gender discrimination in Serbian law. So that's not physical reality. Legal norms are not part of physical reality. So it's obviously that we are not describing physical reality when we are describing norms. But we are describing something which legal scholars tend to treat as some specific layer of reality, which we may call legal reality. So legal reality is basically composed of those legal materials, legal documents, legal norms that are currently in force, that are present in certain statutes, constitutions, some judicial decisions, and that's basically legal reality. So what were you asked usually during your graduation program, for instance in law, is not more than description and, to a certain extent, reconstruction of certain parts of legal reality. So you want to write an essay, let's say, on some part of inheritance law. So what you need to basically do is to pick up these relevant legal norms, and you pick up some relevant judicial decisions, and to present this material. So that's the very first step. You come up with basically collecting and merely describing certain legal reality in usually in terms of the very provisions, or in the words of the legislator, That's description when you are working with legal materials. But of course, since I said this is not purely legal master programs, you may also be focused on how people behave. You may want to describe, for instance, behavior of certain, let's say, institutions or certain segments of society or states in case of European Union law, for instance. So there you would be describing, obviously, some, again, some parts of physical or social reality. And describing social reality, it's not the same as describing physical reality, because whenever you are into social relations, there is always a tendency to add something, maybe to already value something, like to see the things from a certain perspective, which may be already the perspective of a certain value. And it's very important to bear this in mind and not to confuse it with the method of evaluation. Because it's, by the end of the day, it's very philosophical questions. Can we describe reality in some sort of purely neutral, objective way without already introducing some subjective elements, some elements of imposing some values? Just like in this saying, truth is in the eye of the beholder. So, in a way, it will always depend. I'm cutting now really natural sciences. I don't want to claim that this is, there are obviously issues in natural sciences in which this problem is relevant also. But if we put that aside and we focus only on social sciences, yes, then you have the obvious problem whether by the end of the day everything is in the eye of the beholder or the researcher. Because researcher has to pick parts of the relevant reality. So who guarantees that picking up part of relevant realities is objective, is neutral, is not already predetermined by our kind of value assessment of those very events? This is something which we have to bear in mind, especially in a discipline like law and gender. You have the feminist perspective is already, to a certain extent, is already a perspective with a strong value, or the value, the evaluation stance. This also may be the case when you are approaching some issues in European Union, as we saw on the lectures. If we are approaching the European Union as if it is basically full-fledged state, then we already have some sort of a value point from which we are approaching the thing. So it's very difficult. There is a big philosophical quarrel dispute about whether scientific research in social sciences can really be objective, even with lawyers doing the legal material as the topic of their description, whether it can be really neutral or you are always taking some value point. But just bear in mind those things. That's very important. Then we have this conceptual analysis. How conceptual analysis is different from mere description. It's different because we want to go beyond mere description. We want to go to determine some basic features of certain concept. Concepts could be more simple, narrower concepts. It could be broader concept. So obviously, for instance, gender is one such concept. And if you want to say something about the difference between gender and sex, you are into conceptual analysis. Because you can no longer merely describe something. Or you can describe what Serbian legislator or European legislator had to say about, for instance, the relationship between sex and gender. There you are still at the level of description. For instance, you will find in Serbia legal system, you will find articles in the statute, relevant statute, which makes this distinction between sex and gender. But that's just merely the first step. Based on what you can find as your relevant material, you go up and try basically to provide features, relevant features of a certain concept. And this is the task which requires scientific work. So it's this cannot be depicted by, for instance, linguists, because linguists will often provide you very concise definitions of what is sex, what is gender. You will find in the dictionaries distinction between the two terms. But is it the same when we are doing this job by our legal research? No, it's not the same job. We go beyond this simple linguistic definitions. So we want to provide certain features without which this concept would no longer be that concept. So if we ask ourselves, if we have to tell to somebody, what is a bachelor? Somebody asks you, well, I heard the word bachelor. What does bachelor mean?
So it depends if you're talking about studies or like...
No, not in that sense. Not in the sense of degree.
Yeah, I just want, or if you're talking about studies or in the sense of...
okay, yeah. In the second sense. If we are speaking about bachelor as a status of a person, how would you describe it?
It's just a phase of education.
No, not that bachelor. I picked that. Well, that's also showing you that it can be confusing because you have words with the same words with different meanings. The other bachelor, the bachelor who is usually described as a non-married man, that's a bachelor. Non-married man is a bachelor. Have you heard the term bachelor? Neženja? Yeah, bachelor is English word, yeah. So basically you will find this dictionary definition. Non-married man is bachelor. So the term does not apply to women. It applies to men. And that's it. That's a linguistic meaning of the words. And in the step of describing something, that would be enough. But for the purpose of going into conceptual analysis, this will not be enough. Why? Because I will ask you questions like this. A man who is in a long-term relation with a woman living together in an apartment for 5 years, is he still a bachelor? A man who was married, then divorced, continued his life without being married, is he a bachelor? Is Pope a bachelor? So when you ask these questions, and these are some sort of kind of borderline cases, you obviously need to tell something more about the very features which at first glance they look very kind of self-understanding. Well, it's a man. Well, it's an unmarried man. But yes, then we may ask, well, does it also count for a person who was born as a woman but feels as a man and identifies socially as a man? Can that be also a bachelor? Does the bachelor apply to this case? And so on and so forth. So in order to answer those questions, you need to come up with the composite parts of the concept bachelor and to really dig into what does it mean to be unmarried. Let's ask this question. If man desperately wants to be married, but he's ugly and he cannot find a woman to marry, is it still the same case as someone who deliberately does not want to get married, even though he can eventually get married? Are these two cases the same cases? So you see, when you want to dig into the concept of bachelor, there are far more questions that you may want to ask yourself. What does it mean to be not married? And you may also ask, who counts as a man? Does your willingness or unwillingness to marry is also important? Because basically, someone who has the status of a pope willingly decided to go into one kind of social order called Catholic Church, which by its own rules forbid priests to get married. But that's basically based on the will of those persons to exclude themselves from the very set of people who can marry. And there were other examples in history, like in many cases, like soldiers, for instance, in Roman Empire, during some period of Roman Empire, they were also forbidden for being married because it was thought that it is somehow preventing them from really being committed to the to being good soldiers. So does all these elements or all these examples, how can you square them with this simple definition? So if you are into conceptual analysis and lawyers' works are almost always picking up some concepts, yes, you want to say something more. You want to say something more. Very often, you want to take a legal concept which is not even there in some legal document. It's not even there. So, for instance, in our legislation, you will never find a working harassment, i.e. mobbing, that does not exist as a phrase or as a word which was used by a legislator, which does not mean that we cannot speak about about work harassment or mobbing, because it's there. One or more articles of a statute, and we are kind of based on these materials, based on our description and interpretation as well of these materials, we have come up with the concept of mobbing, for instance. Are you following me? Is it clear what I'm speaking about? So lawyers or writing about law usually implies writing about already existing legal concepts. But sometimes part of this analytical work can also, this is something which no one would expect from you in your master thesis, to propose some completely new conceptual framework to depict some legal reality. So come up with a completely new concept. That was basically the case when mobbing as a concept was invented, because you may be sure that there was always some bullying on the workplace. In the history, of course, if you go further in history, we may find even more terrible examples of the status of the employed at the workplace. But the whole concept emerged only in, let's say, 1990s. It was not known before that. So now we are speaking about bullying at workplace or mobbing. So, for instance, in the area of law and gender, you will hear many scholarly arguments in favor of the new concept called femicide. You heard that? Femicide, like the intentional killing of women, mostly because they are women. That would be some rough idea. So you have claims that we will better understand reality of, like usual reality of violence with a lethal consequence. So counting dead women. So obviously you can describe things in such a way, saying, okay, this year we had like 50 women were killed 50 women were killed. Well, that's one way to describe the reality. The other way to describe reality would be say, okay, 50 women were killed. Most of them were killed by their partners. So that would be another piece of information describing things. Then you move on and you say, okay, 50 women were killed by their partners in some sort of a family violence episodes. This would add something else. And then you might want to argue it's no longer good to think of those cases as mere cases of homicide, which is now the only existing category in law, but it would be preferable to think of those cases in terms of femicide. Even though the law has not changed, even for the purposes of understanding the reality, it's good to introduce this concept. Maybe the next step would be to argue, let's change law and include a femicide as a particular and different criminal offense. But in doing that, we are moving from conceptual analysis to this last method of evaluation. Why? Because we are moving from the law as it is to the law as it should be, ought to be. Whenever you are proposing something should be this way and not the way as it is now, you are making a value, you are making some sort of value statement. If I tell you this wall should be green, I have to have some argument that is based on some value. This value can be a static value. I can simply say, okay, green is much better color than this pale yellow color, which is terribly ugly. Well, that's not some big argument because we can always quarrel about our tastes and aesthetic preferences. But if I say something like, well, there are scientific studies which shows that this version of green is psychologically much preferable for the studying experience, then I'm putting a little bit more of justification in what I'm proposing, but I'm also providing you with some sort of, scientifically justified knowledge, which is again some sort of a value that I'm proposing. I cannot provide you any sort of moral argument for painting a wall in green rather than in yellow, but in a number of cases when we are proposing something, for instance, proposing a femicide, obviously we would be in the area of proposing some sort of a moral good. It would be morally preferable to treat those cases in which women were killed by their partners simply because partners felt that they are in a certain way, they objectify the women in this relationship, and at some point thought, okay, I can treat her as an object to the extent that I can also take her life. So something of that sort, that would be a kind of moral justification. Of course, this would be a tricky moral justification because there will be a lot of arguments against this step. But now we are just speaking about different methods of approaching topics. And in the step of proposing some new law, legislation, or anything like that, we would be making evaluation, so making some sort of value statement. Is it okay? Do you follow, understand? When we are very often making these kind of statements, and what is the other method that we are very often using in order to make this value statement? We are very often using the so-called comparative law method. So it is very often the case when you have writings about law nowadays, especially when the materials are so available. So I can find, for instance, some pieces of Chinese law which was unimaginable like 30 years ago, or people in China can find something about Serbian law which was unimaginable like 30 years ago. Well, then, yes, I can get into the comparison between China's and Serbian law or Mexican law. But of course, the very important thing, if you get into the comparison, you have to have the reason why you are doing that. Because I will ask you, why the hell you are comparing Chinese, Mexican, and Serbian law? And the answer, well, I know Chinese, I know Serbian, and I know a little bit of Spanish because I watched the soap opera, Spanish soap opera. That's not a good answer, obviously. That's not the reason to go into comparison. So you will already have to have a point why you want to compare certain things. Why you want to compare certain things. This is profoundly methodological issue. Sometimes there are more obvious reasons for comparison. For instance, people writing in the area of former Yugoslavia would very often compare legislation of the countries that used to be part of Yugoslavia. So they will take, okay, Croatian law says this, Bosnian law says this, Montenegrin law says this, Serbian law says this. So because they all get out of the same legal system, sometimes it's interesting to see, especially if certain institute legal concept or legal area is differently regulated in those countries. Sometimes it makes sense to refer to the well, again, Chinese example, if you want to, especially if you want to compare, you know, like we were socialist country, China is still overall socialist country, so there are elements that might be comparable in that sense. So you may ask and argue that there are reasons to compare those things. Well, if I'm comparing how European Court of Human Rights have devised certain practice, it may be very important to compare it with Inter-American Courts of Human Rights. And yes, I may come to certain cases from Mexico, which are relevant for my discussion. But there has to be some point. And you are not comparing just for the sake of comparison. You are comparing very often in order to show either that something is good with us or something is bad with us. And you are trying to show, well, look at this. Something is done better in this or that place. Let's change our law. Let's correct our practice in order to be better. So very often comparison is part of your justification why we should move that direction or that direction. Very often, when we are writing about something, we have historical exposition of how certain concept used to be regulated, because we want to trace back to the originals how something was devised, and we want to see, for instance, we want to write about European Parliament, how European Parliament through time expanded its competencies, became more important actor within the institutional setup, and you start with history. You start with the very first kind of formation of the parliament. What were the initial competencies? What are the competencies now? So that's also something which is a very, so to say, a regular method used in writings about law. Then there are some other methods which we will definitely not go into, but when, for instance, you get into introduction into the economic system of the EU, you may get this economic perspective of certain legal institutes, and yes, you may approach those institutes by using the method of the so-called economic analysis of law. Sometimes, there are attempts to approach things from this setup from this toolkit economic analysis. And as you could see, when you use evaluation, you're very often using some moral values which are also treated as political values. So that's generally perspective of some normative political theory. So this is how political philosophers tend to treat legal issues. When you're approaching it from the economic perspective, then you see how economists do with law. When you are using some techniques of description which are more sociological in nature, using, let's say, interviews, public opinion polls, some focus groups research. These are sociological methods of describing certain behaviors. So there are plenty of methods. Now I just gave you some very rough sketch of the whole picture. Of course, if you need any sort of assistance, any sort of help, when you come to the point of writing something and you have some dilemmas, be free to contact me. This is really kind of the very, very general and broad presentation of all these issues. We could use hours for talking about each specific topic that I raised tonight, but we have to stop somewhere, and I suggest that we stop now. But again, this does not mean that you cannot put questions, make comments, if you have some.
Can I ask for this, for example, it's for these assignments we have to write in the political system, is it, do we have to follow most of these things?
No, these are really short things. I mean, basically you have to, since the answers are very short, you basically have to really focus on the answer to the question. and then try to support it with certain materials out of what is given to you. And again, quoting, your answer goes directly to Moodle. If you have any kind of materials that you are referring to, put in a separate Word paper, Word format paper, and attach it. Because those words otherwise characters will count you within the number of words that you are allowed to use. So it's preferable to attach it as a separate document. Well, in such a short answers, you want first to show me that you have some specific answer to the question, and you want to show me that there are some arguments why you think that this is the answer. So that's the most important thing. So structure the responses in such a way. This is my answer. These are the arguments. 1, 2, 3, or if you have, like space, like for some counter arguments to this would be this and that, but I disagree because of this and that. But usually there is no space for rather long answers. But my recommendation to you is that you really use all the available words. Try to use as much as possible. Don't take anything as, like presupposed. So that's kind of the basic suggestions regarding the assignment. Okay?
So maybe stupid question, but for example, if
no question is stupid.
Okay. If something is in your presentation, but you not see a citation, can we just
you can just
the same question without citation, or should we mention that there are?
Yeah, you can put that it was from the presentation. You can put it's not something which you have to quote in specific way. You just put this was quoted from the presentation. Any questions from online people?
Dear Professor, thank you for your presentation. Laco noche.
Laco noche. Okay. Okay, see you guys then. You just follow. This was exceptionally for both master programs in this version, but now you follow just your both of the master programs with the schedules that you have. I will send this material via email to both groups of students in a joint mail. So that's all for tonight. See you on some other occasion on both masters. Thank you.